This Honorable Court of Appeals is now in session. Please be seated.
Good afternoon, everyone, and welcome. We're pleased to have you with us this afternoon. We have 3 cases on the afternoon docket, and they will be heard in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes to argue. And if there's more than one counsel to argue, that will have to be divided among you. The appellants have the right to reserve up to 5 minutes of your argument for rebuttal. And if you would, when you come to the podium after you've introduced yourself, let us know how much you wish to reserve, and we will program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Plofchan versus James Hughey et al.
Good afternoon.
Good afternoon, Your Honors. My name is Tom Plofchan. I represent Paul Plofchan in this matter, and I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
Okay. May it please the court. Mr. Plofchan is requesting reversal of the trial court's dismissal of his case as it's not warranted by fact or law, and also based on the fact that the court refused to permit a second motion to reconsider in light of falsehoods revealed in the Appellee's billing records in this case. As the court's well aware, dismissing a case for failure to abide by discovery rules is a severe sanction that runs counter to the judicial system's general objective of disposing of cases on the merits. And it's not generally favored in circumstances where lesser sanctions are available, as this court said in Moody v. Hutchinson. More importantly, this court has also indicated in Lowry that there's a 2-prong requirement that failure to respond to discovery, if it actually exists, requires both a tendency to cause a delay and to be scornfully and willfully stubborn. In this case, we're complicated by the fact that there is actually no evidence that the trial court relied upon. Not one evidentiary hearing was presented. There was a motion, there was a response to a motion to dismiss, but no evidence. And yet, despite that, in its ruling, the trial court made a finding of credibility of my client. When my client didn't speak at all, has never addressed the court in any history, and disturbingly, the trial court said in its findings that over the course of time, he had reviewed the demeanor of my client in court. My client had appeared twice. There's nothing in the record that my client ever spoke anything other than "good afternoon, Your Honor." That's a disturbing issue in terms of if you're going to evaluate the credibility of a party based on their demeanor when they're not being examined under oath and they've provided no answers.
Counsel, wasn't the credibility determination also based on responses in terms of depositions and what was provided through the discovery process? And not exclusively based upon demeanor, and perhaps not even primarily based upon demeanor.
Well, I think we have to look at the judge's answer ruling first, where he says not only did he say that he was relying on items that were not in evidence, as this court has indicated most recently in the last year, that something just because it's attached to a memorandum is not evidence. There was no evidentiary hearing, but the court went out of its way to specifically point out that it had viewed my client and he had to make a decision of my client's credibility, and he did so based on a perception of demeanor when my client didn't speak at all in the court. So the question then becomes, is that become an abuse of discretion if there's no evidence and there's no credible basis based on a client's looks to determine whether or not they're credible?
Counsel, was there any request for an evidentiary hearing in this case? Did your client make a request for an evidentiary hearing in response to this motion for sanctions and attorney's fees?
Well, Your Honor, that's an interesting issue because we argued that to the trial judge as well. When the other side makes a motion for dismissal, it's their burden to be persuasive on that motion and call for an evidentiary hearing. A defense or a defendant is not in a position where they're inviting a discussion or an evidentiary hearing. When the other side didn't request an evidentiary hearing, we were, I think, permitted to say that, hey, this is an issue that is moot because they're not going forward. I don't know of any case in Tennessee or any other jurisdiction where it says that because someone makes a motion, the opposing side has a burden to bring it forward to the court and to ask for an evidentiary hearing, especially when there's no rule that I can find of that allows the court to find something merely on the briefs when there's, without a statement that they're doing so, without any allegation or any indication that they're going to receive something as evidence.
Counsel, did you raise this issue in your motion for reconsideration?
We did. We said that there was no agreement and that they had the burden, and this was an attempt to improperly shift the burden in this case. So what we have to then ask the court to look at is in the entire context of this case where there was a dismissal, not only is there, I believe, we've gone through and identified several areas that are abuse of discretion, but we also have to put this in the context of what has been facetiously, we refer to it as facetiously, the appellant does, but the other side has talked about an appropriate litigation strategy to seek discovery that of material that they already had or had access to and were aware of. And frankly, this isn't the appropriate time, but we think that that actually runs counter to Rule H 3.4D section with regard to not providing frivolous discovery in this case.
You're saying that a party should not ask for discovery if they have some evidence already?
If they have the actual discovery, if I have the documents that I'm asking, I think the appropriate discovery response is to ask someone to authenticate it, do through request of admission, say that yes, these are the documents, or you certainly have, or if you wanted to, Judge, you could say, Judge Clements, I'm going to hold that in abeyance because it could be a trial strategy to ask you, do you have this document in that trial? I'm going to impeach you with it.
Do you have any evidence to support, any authority to support this position?
Just the ethics rules, Your Honor, in terms of it's frivolous if you're asking for that which you have.
Which ethic rule?
3.4D.
3.4D.
D, that one should not engage in frivolous discovery. And my understanding, I actually searched Tennessee.
Now that's an awfully vague.
Yes, it is.
So you want us to draw a whole lot of inferences from that.
Well, actually, Your Honor.
What I hear you saying is we're supposed to hamstring a party who wishes to submit discovery because they might fearfully already have the evidence. And they're going to be deprived of finding out whether your client has altered or destroyed evidence.
I'm not asking the court to decide that.
Sounds like it.
Well, allow me to clarify that.
Please do.
Okay. So what I'm saying is in the context of this situation where they already had it, the purpose of a dismissal is whether somebody was prejudiced. And under the law, what prejudice did they have when it's an issue of whether they could timely use it and was 14 months prior to trial that it was announced that they already had this information.
So you want us to say if a party can lie about not having evidence, the evidence, that lie is of no consequence.
Well, I would never say that because I don't think a party can lie.
That's what I hear you saying.
Well, the problem with the description, Judge Clements, with all due respect, is that it assumes a fact that's not found in the record because my client didn't lie.
In this case, the trial court found that your client knew he had this evidence and denied it on 2 occasions.
The client has never admitted at any time that he had the evidence, nor has he said he had the evidence.
After his wife testified, he said, oh yeah, now I remember.
No, so it's very important. The issue of...
What did I say that was incorrect?
Is that he said, I have access to the work product of my attorney. That's what was different. It wasn't the Group A messages.
That's part of it, but you're leaving out a lot.
Well, I think that I'm not trying to. I think that the issue is that we have to keep in context that there were 3 separate messages, 2 covered by privilege, and the Group A messages, which he doesn't have, didn't have, and has not had since May of 2015, which was almost 2 years before this case was even brought.
So what's the harm in the other side asking for Group A messages?
Well, he didn't have them, so he said, I don't have any.
Okay.
And so then the issue was, if he didn't have them, and there's no evidence that he did have them because a third party has them, I don't see how my client is untruthful by saying he doesn't have them. The analogy I'll give
I'm not sure I understand how you can take the position that your client does not have Facebook messages. Is it because the messages reside on the internet? Is that why you're saying that he doesn't?
I'll give the example, Judge McBrayer. In a case where I have an iPhone, Mr. White has an iPhone. iPhones, you can put in a code where it says, I keep my text messages for 30 days. Mr. White has a code that he keeps them forever. Now, if someone were to subpoena me and say, give me evidence of your text messages, give me your text messages from October of 2022, the answer is I don't have any because they're not, I don't have them on the phone, they're not obtained by or retained by Apple, they're just what's left on the phone. If they asked Mr. White to produce them, he could. And that was the situation in this case. There wasn't a request to identify anyone you had a text message with. There wasn't a request to identify, did you ever have this? It was, did you have these messages? And the answer is, I don't have these messages because I don't have access to them. And he demonstrated that in his second deposition where he allowed opposing counsel to go into his Facebook account and see that they didn't exist.
But, I mean, he didn't say, the response at least to the request for documents wasn't, I don't have these because of my retention policy or the fact that they were automatically released. He just said none, right?
That's correct. And yet,
so, I mean, I would tend to agree with you that had it been a more fulsome answer, that would have been truthful. But to say none smacks to me as being untruthful.
Well, Judge, is one required to answer the question that is asked, or is one required to answer more than that? And that's a real fundamental question in this case, because my experience is that one is not the guarantor of ill-formed or perhaps not fully robust questioning. So if you ask for something and produce what you have, and the answer is, I don't have any, the answer is none, and that's truthful.
Counsel, is it a truthful or accurate answer with regard to the Group B and Group C messages? And when he says none, and with regard to let's assume you're correct with regard to Group A, isn't there still a problem with regard to Group B and Group C in responding to number 9 in the discovery request by saying none?
Judge, I don't think so, because it was covered by request number 13. And it said that anything but privileged documents, and these were asserted as a privileged document. Now, one of the things that the court also has to look at is the severity of a sanction and so forth, is to what extent...
I want to ask about the prejudice prong, or prejudice aspect on that front. You've made a great deal in your briefing of the timing before trial here, just how far out this is from trial. Is that the way we should continue, or is that the way we should think about prejudice, given that most cases never go to trial? The prejudice that can befall a party is really how much you're spending on preparing for trial and the litigation process itself. And if they had had these messages months earlier, it seems that it might cut into the amount of time, effort, energy, money that's spent on litigating this case, independent of trial.
If they had the messages in March of 2019, which it indicated when Mr. Klein contacted Ms. Bird, and when he interviewed and saw them, took notes on them in August of 2019, I don't see how he can claim any prejudice in February of 2020 that he just got surprised by these messages when he already went to Ms. Chappell's office, who was Ms. Bird's counsel, took notes on, viewed the email messages, and had them completely even before the first deposition of Mr. Plofchan. So if that's the case, I'm not trying not to answer your question, but under the facts of this case, it's very difficult to say how there's any prejudice when almost a year before they were produced by subpoena, he had knowledge of their potential whereabouts. He saw them 6 months before that deposition. He specifically engineered the discussion of, I'm going to draft the subpoena ducis tecum, and then he drafted the affidavit for Ms. Bird. So when all that's occurring, I don't see how he can claim that there's prejudice from any delay. More importantly, the trial judge's issue of prejudice was saying that you did not timely supplement. And I think that's where the discussion about how it's calculated prior to trial. When it was discovered that his wife had seen the matters on the 30th of January, and he was deposed the next day, 2 business days later, they were provided by counsel. 2 business days, and then 3 weeks later, because of vagaries of counsel's schedule, they were a formal supplement to interrogatories or production was produced. The trial court found that that was not timely supplementation because there was a 3-week delay in the formal response, even though 2 business days afterwards, informally, the documents had been provided. And there's no case law that says that the idea is that timely supplementation, which would cause the dismissal of a case, is tied to 3 weeks or 2 days, 14 months before a scheduled trial.
All right, thank you. Your time is up.
Thank you.
The appellee. Yes, sir.
May it please the court, Kevin Klein for the Vanderbilt defendants in this matter. The issue is discrete. Did the trial court abuse its discretion in dismissing Paul Plofchan's case and awarding fees as a discovery sanction? And the answer, it's a resounding no. And the reason is because Paul Plofchan withheld, concealed, covered up. There's no polite way to put it. He lied about the existence of bombshell evidence. Now, looking at all the facts, and I don't understand the argument there was no evidence. There were reams of materials submitted with our motion for sanctions. Mr. Plofchan's first deposition, Mr. Plofchan's second, his wife's deposition, all the discovery responses. We submit all of that, and the court concludes Plofchan's blatant prevarication and misconduct warrants the most severe sanctions. That's fully supported by the facts, analyzed under the appropriate legal framework, and within the range of reasonable decisions. But I'll go further than that. It's not just within Judge Brothers' discretion. This is the right decision. And I'll explain to the court why. Let me set the stage. May of 2015, Paul Plofchan was then a first lieutenant in the Army, arrested in Nashville, charged with public intox, obstruction of justice, assault, whose charges were dismissed. The appeal, the underlying case, it's a little bit about what happened, but more precisely, it's about a years-long cover-up. In the second amended complaint, Mr. Plofchan says, I wasn't intoxicated. I wasn't pretending to be Russian. I didn't resist. There's no basis for any charges whatsoever. Meanwhile, on his phone, on an app, Facebook Messenger, are a series of messages back and forth. In 100 pages of briefing, you know what they don't talk about? What do these messages say? They sure don't quote them, nor do they talk about the substance of them. And there's a reason. There's a good reason, because they're explosive. I'll just give you an example. Plofchan asks, and what were we doing when the cop pulled up? Madeline Bird, you were peeing on your shirt. That was probably it. Forgot about it. Plofchan, oh, like I peed on my shirt, so I took it off? Bird, no. Your shirt was off on the ground. You were peeing, accidentally peed on top of your shirt. Bird, you'd been speaking Russian to me too. The Russian never stopped. You definitely didn't make it easy on the cops. That's the tip of the iceberg. That's what's on his phone while he is, approving a complaint that says just the opposite. But now let's talk about how he answered our discovery requests. We issued discovery requests late 2018, and this is the request that the court has asked about: any and all emails, text messages, or other correspondence with Madeline Bird. Response, none. All emails, letters, text messages, other correspondence related to the incidents. Response, object as attorney-client privilege communication and or work product. Here's what's important. A, he flat out denied the existence of this. B, no privilege log and not a single document produced. This is obstruction from the outset. So we file a motion to compel. There's got to be something responsive to something. And the court grants it on various levels, including compelling the other side to respond to request for production 13. That's the one, give us all the messages with Madeline Byrd. You are compelled to answer that. Responds, supplements in the spirit of cooperation, none that are not privileged. No privilege log, no supplement to RFP number 9, simply nothing. Now, meanwhile, we are trying to find Mrs. Byrd and find out if she has a different version of the events.
Counsel, I want to ask you about that in the context of the prejudice question in this case. The trial court said, looking at prejudice, says, defendants accepted his response as true, and they saw no need to obtain discovery from Ms. Byrd. Defendants could have immediately pursued discovery with her and would have obtained evidence that was beneficial to their defense. Weren't you looking essentially throughout for any information that Ms. Byrd had? So how exactly was your client prejudiced if the harm is you would have looked to Ms. Byrd, it seemed like you were looking to Ms. Byrd all along.
There's actually prejudice on a number of levels. One is additional time that we invested in getting information from Mrs. Byrd. So he responds 2/15 of 19 with no documents, nothing responsive. We go on this months-long trip around the sun, having to do a background check to get Ms. Byrd's information, to be able to get a hold of her mom, to be able to get her information, to then go through her counsel, to then finally get in touch with her. So we have quantifiable months-long delay, 6 months-long delay before we know about the existence of these messages. But when we talk about prejudice, there's also another prong that's really important here, and that is prejudice to the system. That is prejudice to the discovery process as a whole when someone just flat out, inexcusably makes false statements. And I'll give you another one that they don't want to talk about. During Mr. Plofchan's deposition, we asked him, okay, number 9, did you conduct a search, provide responsive information? Conducted a search, didn't have anything. Number 13, same thing. Conduct a search, provide responsive information. Yes, I did. Nothing there. Then we say, Madeline Byrd, after you go your separate ways, did you ever have any further communication with her? He says, I don't believe I ever spoke to her. No. Well, that's incorrect, false. That's an example of we did ask them, did you have communications with Madeline Byrd? And when I read this, when I reflect on this, what comes to mind is cross-examination is the greatest engine for discovery of the truth. We put Paul Plofchan through the ringer of cross-examination to test his veracity. He failed over and over again. And so in the cases analyzing discovery sanctions, you actually see a few different trails. You see upholding default where there is months-long, year-long delay. You also see upholding sanctions when there is effort to suppress the truth. Effort to suppress the truth. And that's exactly what happened here. So to say, well, trial's in 6 months, what's the big deal? I would respectfully submit, and I believe this is what Judge Brothers appropriately concluded, that's simply not good enough.
Counsel, why wasn't an evidentiary hearing necessary here, given the nature of the response from Mr. Plofchan? And Mr. Plofchan says, I don't remember. He says that you were looking for this information and that you had it earlier than you say you did in terms of the email responses. Why wasn't an evidentiary hearing necessary to resolve those questions?
A couple reasons. We can look at the responses themselves and tell that they are inaccurate. We can look at the deposition, the first deposition, and know that what I just read to you is inaccurate. We can look at his second deposition and know that just based on the record, it is inaccurate. In fact, during his second deposition, I don't know that we fully fleshed this out, deposition with the wife, they reveal the existence of messages that are still on Paul Plofchan's phone. We say, give us everything you have. He then provides 10 pages, but that's not it. That's not all of the messages. We don't get all of them until we get the subpoena back, the response back from Mrs. Bird. So he doesn't even, when the jig is up, he doesn't come clean. And in fact, in his second deposition, we ask him, okay, so you gave us 10 pages. Is this it? Are there more? No. I don't remember any other ones. That's incredible.
So was Ms. Bird ever deposed in this case?
She was not deposed.
Just subpoenaed for her messages or communications
that is
with
correct.
Mr. Plofchan. Okay.
That's correct. She was in Washington, D.C. at the time. We cooperated with her to try to...
And so that was that response to the subpoena then filed in support of the motion for sanctions?
Yes.
Okay.
Yes, that response to the subpoena, an affidavit authenticating those, all submitted with the motion for sanctions. So, and then also, I guess another, I want to not leave that without saying, these types of motions are decided on the record not infrequently. This is fully within the trial court's authority to decide these cases on the record and to consider the evidence that is in the record. And this leaps off the page. This leaps off the page as inaccurate, deceptive, and so we didn't see the need to request a evidentiary hearing. Incidentally, this was in October of 2020, which the whole world was on a complete lockdown at the time. They didn't request an evidentiary hearing. To the contrary, they submitted affidavits in response. And so let's talk about the affidavits in response. Mr. Plofchan keeps saying, I'm entitled to the benefit of inferences and you should resolve any differences in my favor because they're the movement. The problem with that is, A, you've got over here this whole slew of inaccurate falsehoods, and then we have things where he can't keep his story straight long enough to have a version that's entitled to the benefit of the doubt. So, for example, in his deposition, did you delete anything? No, I did not. In his wife's deposition, did you delete any messages? I don't remember that having happened. We file our motion for sanctions, get a completely different story. The trial court really focused on that too. The affidavits now say, oh yeah, what happened was we had this exchange. My wife asked me to delete those, not have any further communication. That's different than what they told us. And it also, the trial court, I think, appropriately concluded that I don't buy it. That doesn't make sense.
Counsel, was there a request for an evidentiary hearing by Mr. Plofchan in the motion for reconsideration in this case?
Well, there were two motions for reconsideration. I don't remember one in the first motion for reconsideration, and that one we had a pretty extensive hearing on. But let me go back and also I want to comment on something opposing counsel Ray's said. The trial judge didn't have an opportunity to observe Mr. Plofchan. He was only there for two hearings. Well, we went back and looked at the video, Judge Brothers' videos, all of his hearings. We went back and looked at that. And in fact, Mr. Plofchan was at 3 hearings that were over an hour. So we're sitting up at the table for 3 different times of over an hour, during which Judge Brothers is hearing from counsel but able to observe Mr. Plofchan. Now, for anybody who's tried jury trials, you know the jury's looking all the time. And in fact, in jury instructions, the jury is permitted to take everything into consideration. And so, Your Honor, I think that you're right when you say, well, it was not just his observation, it was all of this stuff. And you take all of this stuff, plus the trial judge's observation, you stir it around and you get, this is blatant prevarication, which is what the trial court found and we submit is entirely appropriate. And I guess, as I'm closing in on my time being up, I would note that Tennessee courts, in your position, defer to the trial court's judgment. Tennessee courts, in your position, understand the trial court is closer to that. But I'd like to pull out a quote from Langlois, which is 332 Southwest 3rd. And this is quoting a U.S. Supreme Court case. And what the Supreme Court says here is, the most severe in the spectrum of sanctions provided by statute or rule must be available to the district court in appropriate cases, not merely to penalize those whose conduct may be deemed to warrant such a sanction, but to deter those who might be tempted to such conduct in the absence of such a deterrent. There are two things going on. There is punishment for behavior that is making sure that everybody who practices law in Tennessee understands that you can't play fast and loose with the rules here. And I guess taking that and then holding up next to it what Judge Brothers wrote in his order denying the motion for reconsideration, Mr. Plofchan's inexcusable conduct offends the very foundation of our civil justice system. In my 22 years, I've not seen bombshell evidence like this. In my 22 years, I've never seen a cover-up like this. In response, we have a series of mental gymnastics to try to excuse something that leaps off the page as wrong. So I'll close with where I started. This decision is well within Judge Brothers' authority. It's not just that, though. This is the right decision to protect the system. There must be meaningful consequences when somebody doesn't follow the rules. Thank you.
Thank you, Mr. Klein. Mr. Plofchan, your rebuttal.
Thank you. Judge Breyer, I'm going to answer the first question. There was not a deposition because of Ms. Bird, because we asked for one, and Mr. Klein sought to quash that, and Judge Brothers, as part of the second motion of reconsideration, granted that motion and would not allow us to depose Ms. Bird. Judge Usman, I want to address, yes, we asked for an evidentiary hearing on the second motion when we said, wait a minute, all this is coming out with regard to what evidence they knew. The other reason why, without casting dispersion on counsel, why there needed to be an evidentiary hearing is because what Mr. Klein represented to you when he supposedly read the transcript from conversations with Mr. Plofchan and Ms. Bird, but what he said to you is not true. He said these were on his phone. Yet at the second deposition, Mr. Plofchan showed that they weren't on his phone and had never been on his phone. Why? Because this was using an app called Facebook Messenger. And Facebook Messenger retains things unless you delete access to it on the internet. The motion to dismiss, not $50,000 plus all costs in the entire case, plus an additional money because we asked for a second evidentiary hearing when this new evidence came to light that they had all this information because the court, as Judge Usman, you pointed out, the court's ruling was that the prejudice was because they gave up their opportunity to get discovery, and yet they had continued in discovery and had spoken and been speaking with Ms. Bird since March of 2019, which was 2 years before the trial.
All right, your time
my time is up.
Way over time.
I apologize.
Thank you.
Judges, thank you very much for your time, and we thank you for your consideration of this matter.
Thank you both for your arguments. We'll take the matter under advisement. Please call the next case.
Dennis N. Etheridge et al. Versus the State of Doris Etheridge.